Hello everyone, welcome on this grey and wet Geneva afternoon, as we meet, and we have 70 minutes of a very important topic to go through. But I was slightly amused entering here today that this must be the only democracy in the world I know where the press club and the defense and military museum are in the same complex. And I just thought, if there's a hidden message there, I don't know. And thank you all for coming, because this is not an easy location and to find, and it's some distance from the Palais. And lots of people are at the Palais, lots of very interesting things going on there. So for you to find the time and come here and see many familiar faces is very rewarding and very encouraging for the people whose quest is for justice, reparation and remedy in Sudan and what's been going on there. Now, we are going to be focused on a slightly technical and arcane sounding topic, which is the national contact point and the complaint and what happens there. But there have been development. There has been a very progressive opinion from the national contact point in Norway, and there has been a not so progressive response from the company, about which also now we know a little bit more. So we will be taking into that as well, because a letter from the Norwegian NCP came out only yesterday or today. So, but Egbert will be able to fill us in with all the details on that. I do have a few quick opening remarks, and that's to set the tone. We all know about the crisis in Sudan, the separation of the country and the violence and the role that oil played. There was the famous Presbyterian Church of Sudan case years ago in Talisman Oil, which almost went to the court, then it did not go to the court. But we did know that Lundin had a very severe problem, and that has been very well documented by Pax itself, other NGOs. I was at Amnesty in those years. Human Rights Watch also did a very strong report around that. So the conflict has been known. What has been relatively less focused upon is what happens when a company leaves. And what is, we've been talking a lot about responsible exits. And this is kind of an example of irresponsible exit. Now, this is not a unique case, as we will go on and talk about, because it has happened before, many, many times. It has happened in Union Carbide and India when Dow Chemicals left in a very clever manner, and if there are questions about it, I'll be happy to answer that later. I don't want to go into the details there, but I just want to flag that this is a global scenario. Telenor went through a lot of problems when they were in Myanmar and decided to leave, and how to exit became an issue for them. Chiquita, which used to be the United Fruit Company at one time, when it left Colombia, again, that has had a problem, and there has been a very progressive judgment in Florida on that issue, which is something worth keeping in mind as we go forward. And then we have this case in the context of Lundin, which is also worth bearing in mind, about how companies do deal with issues when they have to face liabilities, and when they merge and acquire, essentially to distance themselves. And people in the Niger Delta will tell you that Shell has a similar problem about how it is leaving some of its responsibilities now that it is giving up most of its on the ground situation. So I just wanted to provide that global context as we go forward and focus actually on the situation in Sudan. I have an exceptional panel today. I will very briefly describe them, but because I think we all want to hear from them. We've got Reverend James Deng, who's going to tell us about what's happening on the ground, what he has seen, and what he feels we need to be aware of. We have Anita, who really doesn't need an introduction to any business and human rights audience, but UN Working Group, University of Washington Law School, Anti-Slavery Commission, and many, many other things. And she will be speaking about some of the legal implications of mergers and acquisition. We have Tara Van Ho, an academic who did amazing work at the Essex Human Rights Program. Now she's in the US, and she will also talk about the larger international law consequences and issues. And then Eva will tell us about what Pax has been doing. They've been fighting an amazing battle since the beginning. Egbert is also with us. You're speaking, not Eva. Is Eva also speaking? Sorry? Is Eva also speaking? No. No? Oh, it's, okay, all right.
Eva, I'm afraid.
Yeah, no. Here it, in my notes it was that. But it's Egbert who's led that work, and he will be telling us more about that as we go forward. So in the order will be that, James, we begin with James and hear about the situation on the ground. Then the corporate law and human rights law and where the relationships are. Then Tara talks about international law, and then finally Egbert Texter talks about where things are and what are the next steps that can be. I'll stop there. Thank you. Do you want to come here and speak?
Okay.
Yeah. And I might interject with questions if necessary.
Yes, good afternoon. My name is Reverend James Ninrew. I wear so many hats. One of them, I'm the moderator of the General Assembly of the Presbyterian Church of South Sudan. I'm the founder of Assistant Mission for Africa, an NGO. And the capacity today, I'm standing here as a Secretary General of the Liech Victim Boys. I want to thank everybody that's made it here. I think with our busy schedules, it's not easy for anybody just to leave his place and come and listen. The topic we are discussing today has been in the news, and right now is in the court in Sweden. I'll speak as a pastor in the community that is affected. And when all this happened, I was on the ground. I was on the ground even 2 years before the Lundin could come to the area. I was assigned to Koch Parish. Koch is a place south of Targias, where the base of Lundin is. It's about 23 kilometers. And in 1995, I was posted as a new graduate of theological school in Koch County. And I was there doing my parish work normally. Around 1998, 1997, 1999, things developed rapidly to the worst. Displaced people could come to Koch and being accommodated in the compound, of the church. And we were wondering what was happening. Later on, we discovered that there's an oil exploration headed by Lundin. And there's no way we could reach to them, and there's nowhere we can complain. There was a cut-off area, a contested area between the government in Sudan and the SPLA, but we are behind the line of war. Just to make the story short, I don't know how many minutes was given to me, so I have to manage them. In 2006, after the signing of the peace agreement, we had a civil society churches conference in Juba after the signing of peace agreement, and then we were trying to think. One of the issues that merged up was the oil exploration in Block 5B, which is in Unity State, Block 5A. And as civil society and as churches, we were wondering how to reach to the oil companies that are causing destruction in our area. And we asked the civil society from the north. And by then, Egbert was there and other civil society through the oil coalition, the European Oil Coalition on Sudan. We raised our issue that we need to reach into this company called Lundin. And the only help they could give, by then they said, okay, we'll assess. The assessment came with a report, which is now the basis of the case, unpaid debts. In the unpaid debts, it was detailed what had happening, and then we launched the report in 2008. They did not accept it. 2010, it was officially launched. Then the court case started. Now, I think somehow there was a delay in between because Lundin was saying we did no harm. We are not responsible. And they were denying. But after the investigation, and we know all what happened after the indictment, then it became clear that there is a case between us, between the community in Western Upper Nile and Lundin Company. Just before the indictment, Lundin tried, maybe they have sensed that this case is not going to be in their favor. So they got into merger with Aker BP. Aker BP in Norway, they transfer their asset, 98% of the asset, into the new company called Oran. Oran become now the new Lundin in Norway, under the protection of Aker BP. So now we are seeing, if we see Aker BP, we are like seeing Lundin. And we think that if Lundin could transfer 98% of its assets into a new company, there's a question mark. That is not an innocent transfer or innocent merger. We think that they are trying to avoid to meet the compensation that the court may decide, and the compensation that the people of South Sudan are asking for. And since Aker BP have accepted that, we try to open a line of communication with Aker BP to see how can we settle this. But they have turned a deaf ear to us, and we had to now to go to the contact point, the Norwegian contact point. And we asked them if they could mediate. We had 2 meetings. Those 2 meetings, they did not resolve into something. And finally, I think the NCP has come up declaring that proper merger, proper due diligence was not done, and therefore the merger is like in questions. And if the merger is in question, that means it's not following the guidelines of conduct of business. And we think that we have a case also with Aker BP, because Aker BP, to our point, is Lundin. And we think that they are trying to hide or deny the people of South Sudan the compensation because they have transferred all the money into this new company called Orient. And therefore, we ask the international community and even Aker BP to reconsider their position and sit with us so that we can have a dialogue to resolve this. Otherwise, if they are just waiting to hear what the court will say, I think that will be a risk they are taking. To conclude, since Aker BP decided not to listen to us, and we have already obtained the written opinion from the NCP, I think we will continue to pursue that. If they like that, I think we are ready to go ahead with that. Thank you.
Now we are slightly changing the order for the context to become very clear. We will now have Egbert, who will talk about the NCP part and the campaign part, and then we'll go into the broader questions of the law. Are you going to speak from there?
Yeah, I can speak.
I think the cameras are here, so...
Okay, yeah. I want to be on camera, of course.
I mean, people want to see you also, right? Yeah. I'll go at the end. I'll speak from there. Okay. No, there's a spare seat there.
Okay, good. Thank you very much, Salil. Good afternoon, everybody. Welcome. One thing I'd like to stress that we are not talking about something abstract here. This is not just a legal UNGP, OECD guidelines interpretation thing. We're talking about the suffering of hundreds of thousands of people. We're talking about 12,000 people estimated who didn't survive Lundin's operations in Block 5A. 180,000 who were once or several times forcibly displaced, who lost their cattle, and who had to say bye-bye to their ways of lives, never to recover since. So that's where we're talking about remedy and reparation. Of course, part of the remedy is realized in the Swedish court, which is the truth-seeking, truth-telling and recognition, but not the reparation and compensation dimension. So, shortly, on 11 November 2021, the former chair and still major share owner of Lundin Energy in Lundin, who lives a few kilometers that way along the lake, together with his former CEO, Alex Schneider, multimillionaire, who lives at that side of the lake, right across here, were indicted for complicity in war crimes, and their company, and the public prosecutor requested the court to declare their operation, Lundin's operation in South Sudan, a criminal enterprise, and to forfeit all benefits to a total of 230 million euros. That was on 11 November 2021. Immediately, the company commissioned Barclays to seek takers for its assets. And 40 days later, on the 21st of December 2021, Aker BP and Lundin announced a merger. And that's what we're talking here about, because what happened, 98% of the assets of Lundin were taken into a single-purpose company that then merged with Aker BP. So as James rightly says, we consider Aker BP to be 50% Lundin. Lundin has become Aker BP. We immediately, so the very same day, 21st of December, informed Aker and Lundin that the merger risked to empty Lundin to the point that it would effectively deny the victims of the crimes that it allegedly had committed access to remedy and reparation. But they argued that the remaining legal entity was keeping all the responsibilities. And on the 31st of May, we filed a complaint, where the core complaint was that there was no human rights due diligence done on the merger. There had been no meaningful engagement with stakeholders, and that the merger effectively facilitated ongoing adverse impacts, namely the impact of denial of access to remedy and reparation for the victims. As James said, after a fruitless dialogue process, on 18 June this year, the NCP issued its final statement that I recommend to read on its website. It's really good. The key conclusions are that Aker had failed to conclude adequate human rights due diligence, and it did not cover the risk of negative impacts on the rights of effective remedy of victims. And it had not adequately and independently addressed that risk. And it knew that the risk was there, and that should have ensured that Lundin would be able to address the issue of remedy and reparation of the victims. So basically, this was a resounding victory. We've been put in the right for the core of our complaint. There are interesting dimensions to it. Of course, the recommendation of the NCP was for Aker BP to carry out adequate human rights due diligence on the merger, in retrospect, but also that based on that due diligence, it should seek to take a role in remediation. So that means that the NCP explicitly, so implicitly I must say, says that the legal liability may remain with the now called Orrön Energy, the small entity valued at 2% with former Lundin Energy in Sweden. They may have owned the legal liability, but that the human rights responsibilities are a different domain, and that the human rights responsibilities can actually move, with the assets to another legal entity. And this is potentially a very impactful decision. I think it's completely right. And well, Anita and Tara will go into the consequences for human rights due diligence in the future. It also explicitly recommends Aker BP to use its leverage to encourage Orrön Energy and its main owners to facilitate the process. So thereby, it very explicitly addresses the shareholders. Not only the family Lundin, the shareholders are all the main institutional investors in Sweden and many others. I think that's also very meaningful, and that's also a way forward. Now, what happened since? Aker BP, we sent a letter to Aker BP asking them, so what are you going to do? They responded that they were not going to do anything, that they considered this NCP dialogue as a process to be their human rights due diligence, and they did not consider any acts. They said it was not relevant. Now, this morning, the NCP, Norwegian NCP, sent a letter to Aker BP where it very clearly states that its reaction was inadequate and wrong, that its recommendations are forward-looking, and basically the NCP clearly stands its ground and puts Aker BP in the wrong for not doing what it's supposed to do. So we're looking either at Aker BP that now understands that it's wrong and makes good, or we're looking at a real crisis of the Norwegian NCP. And I would say the moral bankrupt of the shareholders of Aker BP that include the well-known oil major that has such a great human rights reputation relative, that's BP. Thank you.
Yeah, I'll speak from here, and Anita, I'd like you to go next and probably look at. Someone who knows cameras, tell me, is it okay if the people just sit and speak? Oh, okay. I thought the cameras were facing there. So, yeah. Okay. Sure. Yeah.
Yeah. There it goes. All right. Thank you so much. So I'm going to speak about really what happens next with respect to the NCP complaint, and what you've heard about is, of course, the experiences on the ground and the real world impact and implications of this case. And now we're going to take it back into sort of the legal and technical aspects, which can be daunting. And I'm not going to go into the sort of intricacies of the merger, so forgive me if you're sort of a hardcore corporate lawyer in here, right? You can correct me if I speak too generally. But what I will be speaking about, is it on? There, okay. What I'll be speaking on is really just what do we know now about the guiding principles and the OECD guidelines and the context of human rights due diligence and mergers and acquisitions. I was asked to be an expert in the case, and so I did file two briefs or two statements relating to this, and when I was first asked to do it, I actually didn't know what the answer was going to be because there's no book on the shelf that says human rights due diligence or the guiding principles in mergers and acquisitions, right? That the whole issue of corporate transactions of many different kinds and the role of guiding principles is still an underexplored area. So just to say, and if there are researchers in here, right, there's a lot of things you can do. But I did spend a lot of time looking, and I think I found almost everything I could where there were little breadcrumbs of references in things like the interpretive guidance to the guiding principles from the Office of the High Commissioner for Human Rights and other statements and commentaries that had been written to say that at a minimum, when you talk about a mergers and acquisition, the guiding principles and the OECD guidelines for multinational enterprises, right, apply, right, so that there's just a general presumption. But then the question is, well, what does that mean, right? Because again, in terms of that context, if you are the acquirer or there is this situation, as we've seen here with Aker, what are its obligations to engage in human rights due diligence, and what's the extent of it and the nature of it? And it's something that is still underexplored, but I think this NCP decision that has come out goes a long way to giving us some signposts and some guidance. So I just want to talk about that. So the first thing I want to say is that yes, the big news is that when we think about mergers and acquisitions, there is a general obligation under Pillar 2 for a company to engage in human rights due diligence. So that's the first thing. The second question is, well, what does that mean in terms of the entities? And as you've heard here, right, we have the assets that were acquired, we have the assets that were left behind. So, and before that, we had a parent company that was in negotiations that formed a kind of a merger company. So there were all kinds of different entities. And the question is, to what extent does the due diligence have to be taken on the assets that remain and get left behind? or not. And then there's also a question of the impact or the nature of the due diligence. What should it encompass? Should it encompass issues of access to remedy and so forth for, again, the company that was left behind, and is the one where the assets remain in terms of satisfaction of remedy for the parties? And finally, is there a concept that failure to conduct proper human rights due diligence can contribute to failure to provide effective remedy? And Tara is going to really talk about the issue of the right to a remedy under international human rights law. So let me just say that the NCP determined that human rights due diligence for the transaction, right, should have focused on these different issues. And so its finding was that, number one, Aker BP did not conduct human rights due diligence in line with the OECD guidelines. And what it said was that it didn't meet the guidelines in 3 respects. First, it failed to analyze the likelihood and implication of Lundin and Oran being held responsible for grave human rights violations. So right there, it's saying that the extent and the nature of human rights due diligence should extend to this issue of, will there be an adequate remedy for human rights victims, right? That is actually part of the nature of the human rights due diligence. And again, Aker's response was, we did due diligence on the entity or the assets that we were acquiring, right? And they were not connected to Sudan, so that the nature of the M&A due diligence should have been more limited. And the NCP said no, right? That given the nature and the circumstances of this merger and acquisition, right? This is not a garden variety mergers and acquisition. This is a merger and acquisition where you have a company where, at least for part of the company, there have been allegations of war crimes and grave human rights violations, right? So the context of M&A matters, and that's what the NCP, I think, has acknowledged, is that in this context, the scope and nature of the M&A due diligence isn't just on the target or the asset you're acquiring, but you have to look at the business relationships in the entire context. And in addition to that, so that's one thing, right? So the scope needed to be contextually larger than just the target. The second thing was that the context was such that given the nature of this situation, you needed to think about access to remedy as part of the scope as well. So it's the who do you conduct due diligence on, and the what included access to remedy. Because the second finding the NCP made was that it did not properly assess whether Oran would remain financially capable of providing remedy. And finally, it did not take steps to mitigate the transaction's potential negative effect on victims' access to remedy, right? So those are the different findings. And of course, its recommendations were that now Aker conduct full human rights due diligence on the transaction, including internal and external information, engaging stakeholders, and planning mitigation or remediation. As Egbert mentioned, using leverage to support remediation, including engaging with Oran Energy and its owners, and ensuring effective implementation of updated human rights policies in mergers and acquisitions through meaningful stakeholder engagement. So that's another piece of this too, which is that we have to remember that human rights due diligence includes stakeholder engagement, right? So that's the next important piece. So the who do you do due diligence on? Broader context. The what should include access to remedy, and then how includes stakeholder engagement. So those are kind of simple takeaways, I think, but very powerful ones in terms of this. Now, there are a couple of things in Aker's initial response, I think, that the NCP did address with respect to this. One was this issue of, again, the scope of due diligence, right? And again, the NCP, I think, it was good at being able to flag that given the circumstances, the red flags that were acknowledged in terms of the criminal proceeding, that this really was a sort of roadmap for what the due diligence should look at. The second piece was the notion of timing of mergers. So there was a notion that because the relationship or the business relationship in an M&A transaction is so short temporally, that there couldn't be contribution, right? That the idea that you go from direct linkage, right, to get in the weeds to contribution can only happen over a period of time, right? Whereas a merger is a transaction that's like a short date, right, as opposed to like a long marriage. And in my opinion, I said I don't think there is a temporal nature to this notion that linkage can go to causal contribution, especially given these circumstances and the fact that there had been communications in to the company warning them about this issue of potential remedy jeopardy, the pending NCP complaint, that there was enough there that it wasn't as if the relationship was over before the knowledge of these potential consequences were there, so that there was time within the nature of the merger to actually address those issues and to say that the human rights due diligence needed to be more comprehensive. And so you could go from linkage to contribution within an M&A context. So again, I think that's another important takeaway. So I'm going to stop there just to say again, I think that for our community, right, this NCP decision is very important because it does lay out, I think, an important roadmap to say M&A in the context of a situation where there is a serious human rights proceeding that's going on needs to take into account remedy. Very important. And so with that, Salil, back to you, and then I think to Tara.
Yeah, actually it's Tara first, and then I do have a question for each of you to set us moving, and then we'll turn to the audience. So Tara.
Thank you. And thank you to the organizers for having this event. It's a pleasure and a regret that we are back here again having this conversation. Reverend James expressed repeatedly a belief that the change from Lundin to Oren is an intentional effort to avoid responsibility. And I want to say that it's not a belief, it's lived experience. It's an ongoing story. This is a variation in a theme that we have seen repeatedly with businesses who get into trouble for widespread and systematic human rights violations, often amounting to war crimes, crimes against humanity, and genocide, and then wind up their internal operations, change their name, and hope nobody notices. And the impact of that is the denial of the right to an effective remedy. So that's what I'm going to speak about, is what do we mean when we talk about the denial to an effective remedy? And what are the broader implications of this case within that context? So I was brought into this also as an expert witness, largely in what I found to be a rather bizarre debate and response from the corporation, which said, we don't have a responsibility to assess whether or not our mergers and acquisitions have an impact on remedy. That's not in the guiding principles. And I mean, it is. You're supposed to take account of all human rights violations, and the right to an effective remedy is a very clearly defined right within international law, and it is attendant to all other rights. I used to play a game with my students where we would say, which human rights would you throw out? And they would always start with things and end up with torture or life as the last two rights that they would throw out. For me, the last right that I would ever throw out is remedy, because the right to an effective remedy is the ability to challenge your mistreatment in other ways. It is the ability to seek a process that says that what occurred was wrong, and the substance to restore you to the position that you would have been in, but for those other violations. So for me, it is the core of all other human rights. And it's not just the opinion of Tara Van Ho, but it's also the opinion of the Human Rights Committee and the Committee on Economic, Social, and Cultural Rights and the Committee on the Rights of the Child. Every body that has heard this within the human rights community has found that the right to a remedy is a core right attendant to all other rights, necessary for their enforcement and their protection. So the idea that a business that claims to adhere to the UN Guiding Principles on Business and Human Rights, that claims to consider the OECD guidelines, would say that they don't have to consider the right to an effective remedy, I found to be a very strange argument. So the responsibility to remedy includes both a process and a substance, that process to challenge. It is both the ability to go to court, but also for businesses, it's the right to go to a non-judicial grievance process with the business, to work with the business to restore a victim to the position. And then substantively, we should be looking at the measures necessary to restore the victim to the position they would have been in, but for the violation. That includes restitution, rehabilitation, satisfaction, which you may know better as a public apology or an acknowledgement of wrongdoing, guarantees of non-recurrence, which are reforms to one's systems or processes to make sure that what occurred once doesn't occur again, either to the individual victims that already suffered a harm or to other victims in a similar position. And this guarantee of non-recurrence or non-repetition is something that we hear often from victims is so fundamentally important to them. It's why they pursue these cases, because they don't want to suffer this again, but they also no longer want to see anyone else suffer from this. They don't want to see other communities go through this. So the guarantee of non-recurrence or non-repetition is a very fundamental part of business and human rights and what we should be looking for in terms of the substance of remedies. And then compensation is the cleanup for everything that one of those other forms of reparation can't cover. So if you can't restore the dead, then you pay compensation. If you can't restore someone's arm that you have wrongfully removed from their body, then you provide compensation. In this case, compensation became really one of the only remedies that you could get. You are talking about war crimes. You can't restore that. There's no such thing as restitution. You can have minimum rehabilitation. But when you've already wound up all of your operations on the ground, that's also going to be very limited. A public acknowledgement is great, but it doesn't do for the victims what was necessary. Compensation here was what was necessary, and it was compensation that the merger and acquisition was intended to deny the victims. It was intended to move money from Lundin to Norway and insulate, through a separate personality, the ability to go after that money. Now, the NCP acknowledged that, and they said that Aker is to conduct human rights due diligence by reviewing their steps that led to the merger and acquisition and considering the impact that that has on the right to a remedy. They also said that they should take a role in remediation based on their due diligence, or when it's timely and appropriate, to use their leverage on Oren Energy. And by that, I believe that the NCP was saying when the criminal prosecutions in Sweden are concluded, then perhaps it's time to put pressure on Oren to make a remediation. That said, I have to say, while I am 75% satisfied with the NCP decision, which, by the way, for those of you who don't know me, is a very high satisfaction level for me out of one of these cases. The 25% that I'm not satisfied with is that part of the decision. The idea that at some point in the future there will be a time to remediate, that it's not an urgent responsibility of Aker. Because the reality is there's no time in which you fail to undertake human rights due diligence in which there is not a harm received by the victims. That harm is either some sort of a substantive missed issue, or it is a shifting of the burden from the company to do proactive diligence to the retroactive responsibility of victims to have to fight for their rights over and over and over again. That takes up time, it takes up energy, it takes up resources. It diverts people from the path that they were supposed to be on into something else. And we see that here with Reverend Deng. James, I'm sorry, you should not have to keep coming back to Geneva every single year to ask for the international community support in this. That's a harm that he is suffering. So in that sense, the NCP's decision gets us close, but not fully there. The broader implications of this case are that these guarantees of non-recurrence as a substantive remedy need to have real content to them. And the ability of businesses to merge, acquire, change their name, and then drift off into the sea of anonymity is a failure of the international community to require true guarantees of non-recurrence, to require true compensation. And so I would implore the international community to take this as a lesson learned and a lesson to move forward with, to revisit how it is that we allow for mergers and acquisitions to occur. Both the Swedish and Norwegian governments had to allow for this merger and acquisition to occur, so that's a failing on both of them to ensure remedies for the victims before that merger and acquisition occurred. We also need to think through what it means from an international legal perspective that we ask victims to constantly have to relive the trauma and the terror of their own existence, of the harm that was caused to them, because that's a new form of harm as well. And so we are getting really close. We have a very firm decision here that says remedy is something that needs to be considered any time that is implicated as a matter of due diligence. We have a really nice response from the NCP that says that they need to take a role in remediation that's appropriate to their link to the harm, and yet it drops the ball a little bit on that substantive measure that's necessary to really rectify this case. Thank you.
Thanks very much, Sarah. There's a lot to chew over, a lot to reflect. I have at least half a dozen questions for every one of you, but I won't do that. But I will pick up remarks that each of you has made and evolve a question out of that for each of you to start with, and then we can go forward. We have about 30 minutes, yeah. So, Reverend Deng, the first question is to you, and it's linked to what Tara kind of put as a challenge to everybody here. You should not have to keep coming to Geneva again and again with this story to remind the world what happened. You've been with this story, you've been with this incident, you've been with having witnessed what has been going on for decades now. Are you losing trust? Are you losing faith in the system? Are you at a point where you feel you're so frustrated that you want to see where the solutions lie?
I'm not losing trust. I believe the international community and the global community are one. And when there is suffering, the likelihood is that some people are not aware that this is happening. And the media is so active these days, the negative media and the positive media. Both of them are portraying what they think is good. But I decided to come and say it myself, because when Lundin came, they found me there. And I lived there when I was young, and now I'm old. So I know every corner there, and I know every person, and every person knows me. And not only I'm talking on my behalf, but on behalf of the people. The people have given me that trust, and they know I'm part of them, and I have suffered with them. So not everybody will be able to come to these forums. So I think I'm a messenger who is trying to echo the voice of people and tell the story alive. Many of my colleagues have lost their life in this fight for the last 20 years now. And the last person was Reverend Matthew, who was with me. He lost his life December last year. And he was the last person that we were in Stockholm together. So I believe Eka BP or Lundin's, these people also, they have some part of them which is telling them what you are doing is not correct. And I'm appealing to that part of them that they should listen. They should listen. They should not enjoy the suffering of people. For what? I don't really understand. But I think the legal system also is there to address issues that we are not able to address. And the court that we are in now is one of those examples. So I need to come and wake up the hearts of people to listen. Thank you.
Thanks very much. Now, Egbert, next year is the 50th anniversary of the OECD guidelines, to start with. And NCP is seen as one of its outcomes. Some call it success, some call it failure. OECD Watch has done an amazing work looking at its effectiveness over the years. And if we look at the opinions that have come out, this, of course, is one shining example, but the Gamma was another one that we knew about, and Telenor was another one. So there have been a few redeeming examples of that. But if Aker BP continues to pursue the path it seems to have been pursuing, is the model in crisis? Because you hint at that towards the end of your presentation. So I just wanted to dig a little deeper into that.
Yeah, I think you're completely right. I mean, in many ways, Norway has been a shining example of a government that promoted responsible business practices. It has sent very strong letters to the European Union about the omnibus and the CSDDD, saying it should never go below the OECD guidance standard. That's only very recent. And now we see that one of the largest Norwegian companies gives a big finger to Norwegian government's independent panel on business and human rights. So it must have consequences. So there are two, I mean, it's not going to be Aker that's going to move without pressure from outside, and the pressure can only come from the government of Norway and from its shareholders, of course. And it's very clear what the shareholders, I believe, should require from Aker. And among those shareholders are all major Norwegian institutional investors, and BP, as I mentioned, but also the Norwegian pension fund. And it's very clear what they should require from Aker BP, and that is a time-bound public plan for renewed human rights due diligence on the merger. Meaningful stakeholder engagement was mentioned. A reassessment of its role in the merger, and a leverage strategy versus Orange/Lundin. Very clear. If they don't, then I think indeed we're looking at, if even those shareholders who have signed up to or claim to be totally committed to human rights and the UN guiding principles and the UN OECD guidelines fail to do that, then we'll have a true crisis, yes. If not, they're not. Yeah. The challenge is there. It's clear who's got to act.
No, I share your views on the Norwegian government. One of my jokes has always been that Norway is an NGO that happens to have passport controls. That apart, I want to turn to you, Anita, now. You talked about remedies. You also examined the mergers and acquisition and the role of due diligence there. A corporate lawyer will see due diligence in very narrow terms about liabilities and assets, and completely ignore these contingent liabilities, as accountants might call it in that way. What kind of reforms do we need? Do we need legislative reforms? Does it have to be at a national level? Is this a kind of conversation that should be added as a bell or whistle on the Christmas tree of the treaty that's being talked about? Or is there some other kind of, or is there something episodic about a specific case which becomes a precedent for others, if you were to look at it from legal philosophy?
So I think there are a couple different things. First of all, and actually I want to just respond to what Egbert was saying too, and I think that in terms of NCP decisions, they're significant because they can be presidential, right? That they provide us guideposts, both in terms of looking at what's happened, but moving forward, hopefully they will provide guidance to corporate attorneys about what they need to do and what the expectations are if they say that their company commits to the guiding principles. But beyond that, you need investors or you need reforms that relate to the NCP system, which should be that there should be, there are levers which states have which relate to export credit, other types of financing, trade missions, all kinds of things. And at one point, different members of the OECD, right, have talked about this, right? Like what should be the sanctions or carrots that relate to compliance with an NCP finding. So just to say that there's more work to be done there. On the corporate side, there is more to be done, whether that is law reform, open question. There's mergers and acquisitions, but to Tara's point, I think the larger question of this is that there's both what you do when you merge and you sort of divest of assets, but there also is with respect to corporate insolvency, and I think that's another area where, again, you can sort of just dissolve an entity as a way, and if there's anyone in here who's a US practitioner, people have heard of what's called the Texas two-step, right? So there's a very popular way of sort of dissolving a company to avoid liability and tort litigation. And so I think the first step is to sort of say, are there current mechanisms that are permissible under existing either corporate law or insolvency law that provide or that are a barrier to remedy? And if they are, then do we need statutory reform, or is this more a matter, again, of clarifying expectations? On the insolvency side, potentially, right? And I'll just mention one last thing, and many of you are probably aware of this, but of course the Sackler family has been very involved with respect to the opioid crisis and settlements. And again, they have managed in an insolvency proceeding to negotiate a particular way in which they would pay a lump sum, a large lump sum, to settle lawsuits in the United States with attorneys generals and others, different states, in return for never being sued. So they would just be they wouldn't be personally held accountable and subject to suit if they agreed to this settlement. And I think for many people, it was just a surprise to see that it is a human rights issue, right, in terms of the people that would recover from this, who've either had family members who died or suffered. It was held up in bankruptcy proceedings because there were some judges and some lawyers who said, is this right? Do we allow this to happen? Do we give a waiver through a bankruptcy proceeding when we're talking about this kind of a case? It's just to say that these issues are coming up. We don't yet have solutions for them, Salil. So I think, again, if people want to propose, a great panel topic for next year is to really dig into these issues.
It's clear from what both you, Anita, and Tara have been saying that the way mergers and acquisitions are seeing, which is something only investment bankers and corporate lawyers consider, needs to be broadened significantly, and that there has to be some thinking to be done at the regulatory bodies in that regard. And a case has been very cleverly, very well made, obliquely in the NCP letter, but also in the remarks you have made, that M&As cannot be seen without any consequences to the human rights responsibilities. Tara, I want to turn to the 25% of the part which is unhappy, and I agree with you that I've never seen you 75% happy about these things. So I share that when you say that. But when you say that the part, and the fact that, you talked about urgent responsibility to alleviate harm, these were your words. Now, we are talking about a process that has gone on 2 decades already. So we are way past the urgency stage here. So what would be a 3-point formula or something of that kind that you would suggest that will take us there? And if we were to do that, again, the same question that I asked Anita, does it have to be at the national level, international level? And the final question, which is, I think, to everyone here, that we are actually talking about the entire spectrum, from satisfaction and an apology on one hand, and non-recurrence promise and compensation, which does take us from restorative to retributive justice. But the criminal element has not been talked about. So it will be good if there can be some reflection from one of you about, because anyone can write out a check, but if someone has to go behind bars, then the whole incentive structure changes.
Okay, that was a lot in that. Sorry. Okay, so yes, it is true that this has been going on for decades, so the urgency may seem like it has passed, and yet you have heard from James that it hasn't. And you've heard from him that he has to come back here over and over again, meaning that the remedy is still urgent because we should be restoring him and his community to a position that they would have been in before this violation as quickly as possible, particularly when you were talking about what are war crimes, crimes against humanity. And that's, again, like nobody cares what Tara Van Ho has to say about, outside of my students and the panelists here. Virtually no one cares about this besides my mom. But the Swedish prosecutor says that this is war crimes, and the Swedish prosecutor is investigating and prosecuting that, and the Swedish court system seems to be at least receptive to that and said that it's not a breach of the human rights responsibilities of the executives to constantly go back to this issue from 20 years ago because the gravity of the crimes are so significant. So when you're talking about significant, serious violations like this, the urgency never goes away. It's constantly there. And so yes, it's 2 decades in the making, and that urgency continues. And I want to say that for the businesses, it's not just the urgency for James and for his community. It should be your urgency as well, because the thing that is the super secret reality of business and human rights work is that when we feel that a business is acting in bad faith, we do not forget. We never forget. We will bring your name up as constantly as we possibly can in as many places as we possibly can. I will teach your name, your old and your new one, to my students. I will raise them in every panel that I have ever invited to speak on the relevant issue, and I will try to make sure that your Wikipedia page never loses the content of this information. So do it proactively, so I believe that you are acting in good faith, and I have other companies to pursue or other governments to pursue. I'm very happy to spend my time somewhere else with some other bad actor, but show me that you are not one of the bad actors. So what does a 3-point formula look like? First, it is time-specific and time-bound. It needs to be with urgency. Second, you need to be working with James and his community. It needs to be a collaborative process. The idea that a company can on their own independently decide what a remedy and what is adequate is just a lie. It's a lie that businesses tell themselves, but it's not something that is founded in the law, and it's not something that is good for the victims. And then the final thing is that substance needs to be substantive. So it is the guarantees of non-recurrence. And to the credit of Acker, they have reformed their human rights due diligence, at least on paper. I will wait till their next merger and acquisition before I assess it in practice. But at least on paper, they've started the process of guarantees of non-recurrence. But let's see the rest of it. And let's see the apology from Lundin and from Oren and from Acker to James and to his community. And when we have that with some compensation, I'll be satisfied. I'll be 100% satisfied. It'll be an amazing day for Salil and me.
Lovely. That'll be the day to look forward to. We do have 15 minutes or something like that, but I know that Egbert wants to come in and Anita wants to come in. So let's do that first, and then I'll come to the audience.
Well, I have a question. Maybe Tara or Anita or someone in the audience can answer. I had a short exchange with someone from an oil major who is responsible for their human rights impact about the NCP statement. And his reaction was, yes, it would be wonderful if I would, for once, be consulted on human rights impacts of a merger or acquisition that's been considered. But I'm never, and I will never, because the regulators do not allow us. This is all done within a very small silo because no information is supposed to go out. And whenever they're going to ask me to do human rights due diligence on a target, I'm going to do it, then it's going to be in the market and we're in big trouble. So you first have to go to the regulator. Now, my immediate reaction was, come on, is this real? Is it BS? Is this true? I don't know. Maybe somebody in the room knows.
Any thoughts? And I know you want to ask or make a point.
No, and again, we should open it up because other people may have that. And Egbert, it's been a while. Sorry, I need a little more caffeine today to get the brain cells working. But in general, we discussed this previously, if you remember. And the question is, are there mechanisms and techniques that you could still use to have stakeholder engagement and consultation around the issue of remedy, given that this is an ongoing and palpable issue? The answer is probably yes, right? In terms of you while maintaining the anonymity of the potential acquirer, could you still have a third party engage with stakeholders to find out what it is that they would be satisfactory to them? And I think the answer is yes, right? So we could get more into that, and I'll have some coffee and later send you a long email as to what that would look like. But do you see what I'm saying is like you can, while preserving the anonymity, potentially have those kinds of conversations, because it's not so much about the company, it's about the rights holders. And I'll just, again, what I was going to say, Salil, was just that the important point, which Tara kind of mentioned, is that in the NCP recommendations is clearly human rights due diligence via stakeholder engagement, right? So that it's really a key part of the decision.
Yes. Just say who you are and keep it brief, and if it's specific to someone, say who you are asking.
This is Çiğdem from Business and Human Rights Association, Turkey. So last week we were in Paris attending a case under the duty of vigilance law, French law, which was against Yves Rocher, and so the case brought by a Turkish trade union, basically together with Sherpa and ActionAid. So there was this, the lawyers are pleaded against each other and saying that, the Yves Rocher's lawyers claiming that, the company paid compensation to the workers, who were terminated, whose contracts were terminated due to anti-union busting and all these discriminations against female workers, etc. So there is no ground under the French law for those victims to get a compensation from the parent company, Yves Rocher. By the way, again, another mergers and acquisition case, because after this, they opened the case back in 2012, 22, and I think last year Roche sold their shares of their subsidiary, of Turkish subsidiary, to another Turkish company. So another mergers and acquisition case, and in order to probably break the linkages between these, towards the parent company. So Tara and all other panelists. So, okay, apology and then proper compensation. But now the companies are bringing arguments claiming that, oh, but under the national law, they got a compensation from the company. But at the end of the day, the reason why those claimants accepting the compensation is because of the economic catastrophe. And they are blue-collar workers trying to survive. So what your opinions are in terms of the type of the compensation? Thanks so much.
Thank you. Tara, you can start answering. I'm taking to Gerard, who has his hand up.
You want me to answer now?
Yeah, I think
Okay.
so.
So I have no knowledge of this case at all. So I need to caveat this with, I'm always like 3.5 steps away from a SLAPP lawsuit myself. So let me say that remedy, what compensation looks like, will be very determinant on the harm that is caused, so it has to be commensurate with the harm that was experienced. If you are writing, and again, know nothing about this case, but if you are writing a check randomly for $1,000 and you don't really care what the actual harm was that was experienced, that's not an adequate remedy. It is about wiping out the consequences of the harm that occurred. And so that has to be very individual and specific around the losses that were incurred. So I'm sorry that I can't give you more than that.
And just remember again that the precedent from this case is that at the time that the sale is occurring, the parent needs to factor into it needs to do due diligence to say, on its own, is the remedy sufficient?
Yes.
Do you see what I'm saying? So that there needs to be documentation and demonstration that they've done that. And if there isn't, then there's going to be there should be a problem.
But that's the reason of this
Yeah.
French law, right? National law, it fails. These laws, victims can get more compensation.
Ideally, when human rights due diligence laws work well, then victims are fully restored.
Gerard, please tell us also who you are.
Thank you. I'm Gerald Pachou. I muse in business and human rights. Thank you for a very, very interesting and great panel. I have a question, but before a quick point, I think something that has been said but needs to be said time and again is that this case exists because of the persistence of Pax and Swedwatch. And what was really interesting in the approach that they have followed over the years is to stick to the law when it existed, but at least the standards. Not creating, not exaggerating, sticking to what exists and really applying it to the full force. So, and there is a lot of lessons learned in that. Second point is, I will disagree with you very respectfully, Egbert. I don't think that the NCP system is in crisis if nothing happens out of that decision, because we know that the system has been designed to be toothless. But that might be an opportunity, like Anita said, to explore that again. There have been discussion in the past, but we need to give some teeth to the system which don't exist now. My question, to follow up on something that Tara said, we probably all agree that BP should contribute to remediation. What's the formula? Because it's, in a way, it's easy to say, oh, the main actor or the main guilty party needs to remedy. Okay, straightforward. But how do we assess the contribution that BP or Aker should contribute? And how do you move away from the fact that it's very unlikely that the main party will ever do anything? Does it mean that the whole responsibility is transferred to Aker, or what's the answer here? Thank you.
Thanks. You want to take it, or shall I? I think there was a hand here. Yes, there are two hands. Let's take these two questions, Desiree and you, and then we'll have to probably stop. I'm happy to go longer, but I believe 2:30 is our stop. So Yeah. So first Desiree, and then.
Thanks. Desiree Abrahams, I work for ERM. Actually, it's not a question, it's more some insights for Egbert on M&A. So at ERM, within the social team, we carry out ESG DDs as part of M&A. So I love the idea of human rights due diligence within M&A and stakeholder engagement, but as a practitioner, I can tell you right now that is really ambitious because these M&A deals are very quick. Internally, we have to fight to have a broader scope when it comes to the social. So what will happen is you'll get the client and they will say, we just want you to do health and safety because that is a legal requirement. And then we will make the case for a broader human rights due diligence, a broader scope, and they'll say, no, we're not paying for that. So what we need to think about is how can we ensure M&A, the social scope, there is the requirement for human rights due diligence. I think that's where we need to get to. I don't know how it's done.
The legals will respond, but my immediate response to that is, frankly, that due diligence actually does take time for M&A. It's not a quick affair. It's announced very quickly, but there's a lot of groundwork that happens. And just as we tell companies doing human rights impact assessment that the day you think you're going to explore oil in this area, you should start sending your sociologists and anthropologists to talk to the communities, and not on the last day, now let's consult with the communities. And I think the same way, what I would expect a good due diligence mechanism for M&A to have those human rights questions grandfathered into the whole process early, rather than think of it as a last thing, only health and safety, but maybe you have a better answer than that, yeah. And then you, yeah.
I can do the quick one on just a reflection on that. First of all, I would say a couple of different things. The beginning of this was that I think there was a question about, was this a garden variety M&A? It was not, right? So I think I would assume that for any practitioner, the issue of a situation where you're doing an acquisition where there is a target or a company that has been accused of war crimes means that there should be due diligence of a specific kind, right? So I think as a starting point, as we think about due diligence and salience and scope, due diligence is going to vary, right? So, and it's contextual, and that's the whole point. So I just wanted to say that you don't get a free pass because M&A is short. And in this case, this is a very specific, right? So I think that's a starting point to say in high risk or conflict effect, there's like certain situations where M&A must include it. And I think practitioners need to make that case. Second is, what analogies can we make where I think it's starting to happen and it's prudent and money is spent? One is in the area of transfer of data, right? Data protection, privacy, and M&As that involve large amounts of customer data. You do it, right? You do it, because if you don't, there's going to be a lot of potential risk and downside to it. I hope, right? I don't know for your company, but and the new area, I'm working on a guide on this right now in M&A, is forced labor, right? So again, I think using war crimes, data, forced labor is kind of the sort of big issues that kind of can get, I think, your clients to think about risk to them. I would hope it will help.
One question. Please. Yeah,
answer Gerritse. So how do we assess this? Obviously, that's not in the UN Guiding Principles, for which I blame you, Gerald, because you helped draft them. However, how do we assess this? The right is of the victims to full reparation. So where does that go? Well, it goes somewhere, right? Either it stays with the company if they have sufficient assets, or it follows the money to where the assets go. It also remains with the state. So the Swedish state has a responsibility to prosecute, to investigate, prosecute, and where appropriate, punish war crimes. Sweden is prohibited, all states are prohibited under international law from having statute of limitations on that. And then Sweden and Norway have a responsibility to facilitate reparations and remedies. So either that means paying the money themselves or making sure the business pays it. So if Sweden and Norway want to take on the responsibility of paying the victims themselves, they can do that. I don't care where the money comes from, I care where it goes. And on that, I'll say that with this prosecution, the Swedish taxpayers have a potential to walk out with millions from the company, right? The assets that are remaining in the old company are allocated for transfer to the Swedish prosecution should it be necessary. Why isn't that money going to James and his community? That's a flaw in the law, it's a flaw in the system, and it's something that really Sweden has a responsibility to rectify, particularly since the Swedish courts have now required the victims to front 50,000 euros apiece to attach civil claims. Like that's an insane amount of money to ask of a Swedish national, let alone of somebody from South Sudan who suffered war crimes and crimes against humanity. So there's a lot of work within Sweden and Norway to do, and then they have to remedy their own harms. And if they want to take on the responsibility of a company, please have at it. But that right is there, and the responsibility transfers accordingly.
Yeah, it's over to you, and then I have one last question for James to let you have the final word, which I'll come back to. Yeah.
Thank you very much. Hello, Roy Bakhmutsky from Amnesty International. I just have a quick question, and I'm just thinking as my mind goes back to my litigation background, whether there might be any creative solutions here. And I don't know if any of the panelists have an idea, but just something to consider, and perhaps you know whether others have considered it. I'm thinking about what we discussed here about OECD complaint mechanisms being relatively toothless, and yet that they can establish standards. And the question that comes to my mind in terms of a creative lawyering opportunity is to see whether you can litigate on the basis of that standard in civil litigation. I'm thinking about the Milieu Defensief v. Shell case in the Netherlands, where they interpreted the UN guiding principles and standards there to define the unwritten standard of care under Dutch negligence law, and I'm thinking about whether there could be a corresponding argument being made in Norwegian courts and trying to get remedy from Aker BP in a Norwegian court on that basis. Don't know whether that's possible, don't know if we have a Norwegian lawyer here who can clarify, but just thought I'd ask and put that out there.
So I didn't address that, right, because I think it's an open question. I have it like in my, try to figure it out, right, which is that in different jurisdictions, can you now use NCP kind of instances as a way of establishing interpretation, right? And I think it's going to be a while because we don't have a sort of large body. And I think one of the things we probably need to see first, so for those who are in civil society or others here, is that we need cross-fertilization among NCPs around almost citing each other and sort of starting to really, or at least reflect that there needs to be a kind of common vision of the standard, right? So to me, it's more just about the NCPs themselves need to sort of start thinking about what is that precedential or signaling value, and then from there, it might be that courts are willing to take notice. But interesting idea.
I'll just say, sorry. Yeah, the second problem, it's fine to get that as the established standard, but then enforcing it through civil claims is a separate process. The reason that I just threw out the thing at the end around the $50,000 demand of the victims is that part of the benefit of taking these cases in places like Sweden and Norway is in normal circumstances, if you get a criminal conviction, the victims can attach their claim to that criminal conviction. And so it means that they don't have to incur the cost of pursuing their claims on their own, and the prosecutor can do the heavy lifting, and then that allows for the victims to have a more clear path to remediation. In this case, the Swedish courts have bifurcated the criminal prosecution from the civil claims, and for the victims to file a civil claim, they have to front 50,000 euros each. And when you have a situation like that, it doesn't matter if the OECD standards if the OECD NCPs set the standard, and if their interpretation is what's going to guide the court, it becomes irrelevant because the right to remedy in that circumstance is still inaccessible by virtue of the cost. And so I would love to see Sweden fix that hole before they even get to the issue of the substance of NCP decisions.
Thank you. Thanks very much. And James, the final question is based on Gerard's genuine question about what do we want from, if you want if the compensation, who works out how the compensation is figured out. And you said that you would like to be in a conversation with BP Aker and speak to them and talk to them. What would be your asks to them at that time?
Well, the compensation in the traditional South Sudanese is part of tradition. If we got into loggerhead with you and you acknowledge that you are wrong, then for me to be satisfied, you compensate me. Even the domestic disagreement, the wife and the husband. If the husband is the one guilty, then the parent of the boy will compensate them. I did it recently. I think my ask would be, the company have done us wrong, has displaced us, has killed our people, disrupt our normal life, deny us our livelihood, and sided with the enemy. So those are 5 counts. On top of that, we were not consulted. So that is an invasion. They came into our land, they just explored it like there's nobody in that land. They disrupted our livelihood because we have only 2 seasons in the year. One season is a rainy season where we cultivate, and that is a different set of area. During the dry season, we take our cattle into different areas. So that normal life habits has been destroyed. Now, leave alone educations, leave alone normal and the trauma that was caused. So I asked to AKPP, from the records, the AKPP seemed to be a responsible company according to the records. Why on earth they are trying to damage that image? Because of few coins that are blood money? That would be our question. Now, for them to clear themselves, there are 2 solutions. One is to freeze the money they have taken, put them aside until the court decides. That would be one. Number 2, break the merger. Break the merger and let's deal with Lundin. But if these 2 are not happening, then they are part of the court. So they have to decide and take a conscious decision that will free them and also will free us. And what we want from the Norwegian government and the Swedish government is these 2 countries, I think, they have one common. They are championing the human rights issues, and the Nobel Prize is being done in those areas. Why on earth you just allow one company to damage that image that you have created internationally? So they have the right to intervene, and they are to empower the NCP to act and force the company to compensate us. Why should we suffer? And they have taken their good shares of the investment, they brought it here, and they are investing it now, and they are generating money every year, and we are getting losses every year. People are dying every year. So that's the scenario that they need to look into.
It's a very powerful way to end, and I'll just remind us that you're right to say that they have the right to intervene, but I'll take us back to what Egbert was suggesting, that there's also an obligation to intervene. And I'll stop there, and thanks very much for everyone, and yeah.